who's been with us for quite a while, I think shows the commitment that USF has to our chosen field. Jack, as I say, taught at USF from 1973 to 1986. Prior to joining USF, he was the first, and at that point called the acting general counsel of the EEOC. He held that position from 1970 to 1973. Prior to that, he was the director of the National ACLU from 1962 to 1970. And if you think back in your history, you know that that time frame was an incredibly active and contentious time. And Jack handled cases that span things from voting rights, student free speech, and was also at the helm for the ACLU in their work on Loving versus Virginia. After he left USF, he went to the EEOC and was the regional attorney in San Francisco from 1986 to 1994. Many of you who are here today either worked with Jack at the EEOC or were his students here, and we celebrate with you, his former students and colleagues, and hope that you believe we are continuing on the great tradition that he established at USF. The second reason that we have this lecture is to connect with our alumni. And I've been teaching at USF for over 20 years now. That means I have seen a lot of alumni come through the door. I love seeing you come back every year. And this year I went through and we put together a list of where y'all are. And it's to us, it's just amazing. We have people at plaintiff side firms, including Costin Law, Liberation Law Group, DeVito Law. We have major beachheads at all the management side law firms, including Littler Mendelson, Gordon Reese, Jackson Lewis, Morgan Lewis, Shepard Mullen, Davis Wright Tremaine, Seyfarth. It's really hard not to say Seyfarth Shaw, Seyfarth, and Ogletree Deakins. As well as on the labor side, Weinberg Rosen, Neihard Anderson. We have people at major unions, including SAG-AFTRA, California Nurses Association, and the California School Employees Association. A lot of you have been out long enough to go in-house, and we have in-house counsel at very traditional companies such as Maxim, Genentech, Kaiser Foundation, Grocery Outlet, and also at the newer companies like Square, Instacart, Lyft, and Uber. USF labor and employment alumni are everywhere. They are doing compliance work, they're in human resources, they're doing immigration work, and they're also in the government. We have people at the NLRB, at the California Labor Commission, at the US Department of Labor, and city attorney offices from San Francisco to Los Angeles. All you alumni, we welcome you back. We are thrilled that you are here today. You're going to hear a tremendous lecture. I know you always like getting back into academia a little bit. And then after the lecture, you will be able to see our third purpose, which is honoring the achievements of our current students. And Professor Travis will handle that joyous duty after the lecture. And so what I'm going to do now is to turn the podium over to Professor Green to introduce our wonderful speakers for tonight.
Tristin? Thank you. Thank you, Maria. So I just want to make a couple quick thanks before and then get us as quickly as possible to I wanted to thank Kenji Kihano, who has done such an amazing job organizing this for us and generally is a wonderful person to work with. And also our co-sponsors, LELSA, our Student Law and Employment Labor Association, and the Law Review, who's going to publish the talk tonight. So it's really fabulous to see everyone together here. So it's my pleasure and my distinct honor to introduce this year's Pemberton speakers, Dean Angela Onwuachi-Willig and Professor Leticia Saucedo. What an amazing duo. I could go on, but I'm going to do what I can to keep it short. They're both inspirational teachers, mentors, scholars, administrative powerhouses. Before becoming dean at Boston University Law School in the summer of 2018, Dean Onwuachi-Willig was the Chancellor's Professor of Law at Berkeley Law for a brief time across the bay from us. And before that, many years a professor at the University of Iowa Law School after starting her academic path at UC Davis. So she does have some connections to our area. She has won numerous awards for teaching, was recently honored with an inaugural anti-racism professor chair at Boston University in addition to her deanship. She is a true leader. Her work is empirical. She has a PhD in sociology and African American studies, as well as a JD. Her work is doctrinal, it's theoretical, it spans the broad fields of employment and family law. And we owe a special thanks to her tonight because she's also Zooming with us in the dark of the night from Boston. Thank you so much for being here. Professor Leticia Saucedo is the Martin Luther King Jr. Professor of Law at the UC Davis Law School. She arrived at UC Davis from the University of Nevada at Las Vegas in 2010. And her scholarly work really sits at the intersection of immigration and employment, including discrimination and labor. And she too is a true leader, both in her institution, sitting on the board for the first generation students and leading the research migration cluster, among other things. And she's much more widely known in the employment and immigration community than many, many others. She has done deep qualitative empirical work studying masculinities in the construction industry around Las Vegas, which is when I first came across her work. She's done rich theoretical and doctrinal work and also hands-on legal practice running an immigration law clinic for many years. Both Dean Onwuachi-Willig and Professor Saucedo are strong mentors and advocates for students and professors alike, and they're real experts in the field of discrimination and race. We're so lucky to have them with us here this evening for the 16th annual Pemberton Lecture on Workplace Justice. And we couldn't have asked for a more timely talk than one on the intricacies and implications of recruitment in our struggle to increase diversity and promote racial justice in the academic and legal fields. Recruitment is often one of the first places that institutions turn when they want to be doing something meaningful to change their hiring systems. It's often seen as something of a no-brainer first step. And yet, as we'll see, it can have implications for our ultimate decisions, implications that can be surprising and, yes, detrimental to our overarching goals if we're not careful. So I'm very much looking forward to learning more and engaging in this issue with Dean Onwuachi-Willig and Professor Saucedo this evening. So the title of their talk is Superstars, Underrepresented Minorities, and Candidate Pools in Hiring. So our speakers, as you know, will speak as usual for about 25 minutes, and then we'll save some time for questions and discussion. And Professor Ontiveros is going to be managing those questions for us, so feel free to send her questions along the way, and she'll kind of pull them together in the chat. And then just kind of details on how we're working this. If you at this point make sure that your audio and your video are both turned off, that would be great. And once you turn off your video, you'll see up in the little 3 dots up above in the right-hand corner, you'll see hide, I have it written down, but I can't read my writing, hide non-video participants. And that will allow you to actually see the folks who have their cameras on, which will be our speakers. So welcome, Angela and Letty. I look forward to hearing your talk.
Thank you so much, Professor Green, for that gracious introduction. We want to begin with a number of thank yous. We want to begin by extending great thanks, of course, to Dean Freewald for supporting this program, and to Kenji Kiano for really just all the excellent work in organizing this event. And of course, we want to thank our dear friend, our collaborator, our co-founder of the Equality Law Scholars Forum, Professor Tristin Green, who has really just not only enriched us with her amazing scholarship, but also was very, very gracious in extending this very flattering invitation for us to give the 16th annual Jack Pemberton Lecture on Workplace Justice. And I would also note, just maybe even gracefully also, who's also going to be gracious in noting that the 25 minutes does not include some of these brief introductory remarks. It's a great honor to give the Jack Pemberton lecture, which honors, as Professor Ontiveros pointed out, John, better known as Jack Pemberton, who served as the executive director of the ACLU from 1962 to 1970. Under his leadership, the ACLU achieved legal victories that forever shaped many of our lives, in particular, both of our lives, Professor Saucedo and myself. For example, during his tenure, the ACLU, as Professor Ontiveros pointed out, helped gain a victory in Loving versus Virginia, which held that state bans on interracial marriage violate equal protection and due process clauses of the Constitution. And as two women of color who are married to white men who are in interracial marriages, we personally live the impact of this decision every day. And we're grateful, of course, for the work that he engaged in on this case. And Mr. Pemberton's impact, of course, continues to extend to the most vulnerable among us, as the ACLU also helped to achieve a victory in Gideon versus Wainwright during his leadership, which declared that felony defendants have the right to an attorney at trial. As Professor Ontiveros pointed out, he continued to have an impact on the everyday realities of ordinary citizens through his work at the EEOC, and of course, as a law professor at USF for 15 years. And we're delighted to be giving this lecture in his name. We're delighted to follow in the footsteps of scholarly legal giants like Professors William Gould, Juan Perea, Joan Williams, Michael Green, and Susan Bissum-Rapp. We're just delighted to have this opportunity. And of course, we are delighted to have the opportunity to work with each other. So we want to start by asking all of you to indulge us for a few minutes by imagining the following scenario. Imagine a group of 8 law professor friends from institutions across the United States who are enjoying a dinner together after a long day of scholarly panels at a national conference. And these 8 colleagues work and teach at vastly different types of the broad range of the 198 law schools that are accredited by the American Bar Association. Public schools and private law schools, wealthy law schools at universities with very large endowments, and many tuition-dependent law schools at institutions with significantly smaller endowments. Standalone law schools in rural areas that are far from city centers and big courthouses, law schools in suburbs, and still others in the middle of large urban cities. Law schools that tend to win big in the US News and World Report rankings game, which was just released today, like those ranked among the top 10, and others that do not fare as favorably based on the metrics that all of the friends who are dining together agree should not be used to measure the quality of the programs at their law schools. Institutions with racially diverse student bodies and those that could be characterized as lily white, plus many, many more different kinds of differences between the institutional homes of these 8 bonded professor colleagues. However, what each of these friends' schools share in common is the lack of racial and ethnic diversity among their law faculty, and in particular, their tenure track and tenured faculty, whether those tenured faculty consist of clinical or doctrinal or legal writing or skills faculty. As Professor Mia Rodero points out in her book on equal profession, race, and gender in legal academia, data from the Association of American Law Schools, also known as the AALS, indicate that faculty of color, meaning Black or African American, Latinx, Asian or Pacific Islander, American Indian, and multiracial faculty constitute only 14.8% of all full-time faculty at all levels, including professors, deans, lecturers, and instructors, compared to more than twice as many students of color at law schools, approximately 33% of students in law schools. So as this dinner progresses, the professor friends, all white and all serving on their individual schools' faculty appointments committees, begin to discuss the faculty hiring season that just ended. And in particular, they begin to lament yet another failed season of adding to the racial diversity of their faculties, with one exception. Jimmy Lux, He's a faculty member at the highest ranked and the wealthiest law school among the Friends, a law school ranked among the top 10, but not Yale, Harvard, or Stanford law schools. Jimmy Lux proclaims that that hiring season, his faculty happened to land Jesus. But after years of people mispronouncing his name, Jesus happens to go by Jesus. Jesus Johnson, a biracial African-American and Latinx Chicano to be exact, entry-level hire who's a triple Harvard graduate, PhD, JD, PhD, bachelor, served as an senior articles editor of the Harvard Law Review, clerk for the DC Circuit Judge Nina Pollard, before he went on to clerk for a US Supreme Court Justice Sonia Sotomayor, had articles published in the Michigan Law Review and the NYU Law Review when he went on the academic job market. This is the paper trail, at least, of what we would call in our academia superstar candidate. Upon Jimmy Lux's announcement at the dinner table, the 8 friends soon discovered they share one more commonality. Indeed, as soon as Jimmy Lux communicated his good news about hiring Jesus, the remaining 7 professors blurted out nearly simultaneously something along these lines. "You lucky dog, wow, Jimmy, we tried to hire Jesus." And then one by one, the faculty and each end up explaining how Jesus was their faculty's favorite candidate of the season, how Jesus was a candidate of color they brought in for a job talk with great hopes of adding to the diversity of their faculty, and how yet another candidate of color had gotten away from them. Jimmy Lux, always a little bit blunt, smiled widely and stated, "Well, trust me, I feel you. I myself can't believe that we landed Jesus. But I'm surprised to hear that any of you were shocked about not getting him. Heck, we were certain that Harvard and Yale would get him instead of us. In fact, both Harvard and Yale actually extended offers to him. It's just that he had a deeply personal reason for wanting to be in our city. And we figured it may even be a matter of time before they steal him from us. But we weren't resting our hopes of diversifying our faculty on Jesus alone. In fact, we brought in 5 or 6 more excellent candidates of color. You all just didn't let me finish. And we ended up hiring 2 more faculty of color." Jimmy Luxon continued to describe his other new colleagues of color. Now, the scenario I just described to you is not so common, except for the end where, they hired multiple people of color, right? And in this lecture, we plan to address 2 aspects of faculty hiring processes and patterns that build off or could build off of this scenario, and most importantly, that work to maintain the lack of racial diversity among law faculties. In particular, we examine others, but what we call shifting standards within hiring processes, and 2, dual career status and relationship discrimination in the faculty hiring. So in the scenario I described, we saw some examples of shifting standards. In the law firm hiring context, Professor David Wilkins would refer to what happened in that scenario as an example of the superstar effect, whereby law firms center their hiring on Black associates, for example, with only the most elite credentials from only the most elite law schools, while hiring white associates from a broader range of law schools with a broader range of backgrounds. In the law faculty context, much like in the law firm context, the results of this superstar effect are that faculties never actually become more racially diverse, and the reasons why are threefold. First, a faculty hire can only be in one place at one time, meaning only one school can recruit and retain any superstar candidate of color. Translation, very few of us, indeed none of us, can be Professor Kimberly Crenshaw with dual positions at Columbia Law School and UCLA. Second, the superstar candidate of color focus, or the flip side of it, what I have called complementary with an I discrimination, results in little advancement on faculty racial diversity because it produces what I coin complementary with an E discrimination, whereby faculty dreams of recruiting the ultra superstar candidate of color functions as an excuse for not, quote unquote, settling for very well qualified but less than superstar candidates of color, candidates who are often, in fact, quite similar to the white candidates who are ultimately hired. And third, there is a reality of what Professor Jose Moreno calls the revolving door of faculty of color in institutions, with some faculty of color being recruited away by other schools, with some leaving because of climate or other involuntary reasons, and with faculty of color being hired by institutions only when others leave, thereby creating a space in what people have presumed or have come to understand to be a faculty of color spot. And that has, of course, the unspoken assumption that all the other spots are reserved for white individuals. The shifting that is occurring in this context is, of course, all very complicated, but two questions that relate to the scenario that I began this lecture with help us to understand the complexities of this shift a little bit more. So first, consider the fact that the 8 different schools the professors worked at were all really quite different. They had different needs, different missions, different student bodies. Of course, you didn't go into all the details, but imagine they're all different. And yet they were all laser focused on the same candidate of color. Why were they all focused on the same candidate? And why did these faculties believe, or did they actually believe, as Jimmy Lux questioned, that they could unquestionably recruit the Jesuses of the world, such that they could put all of their eggs in one basket? And second, are faculties just that bad at hiring? Meaning, do they repeatedly make the same kinds of mistakes with white faculty candidates? Meaning, do they insist on extending offers only to superstar white candidates at all levels? And if not, why is it that they insist on such credentials when the faculty candidate is a candidate of color? In looking at these shifts, we see on the one hand how gettability can be shifted in numerous ways as a rationale for excluding candidates of color from law faculties. For example, in one instance, the concept of gettability may be employed as a means of excluding a superstar candidate of color because a candidate is viewed as unattainable. The faculty may predict that the candidate will have too many offers and thus would be ungettable. In such instances, faculties never even look at the candidate, which sometimes leaves them underplaced or even not placed at all because of a fear of bidding wars that will take place as a result of multiple offers that the candidate has yet to receive. In another instance, as we saw with Jesus, gettability is entirely ignored. The superstar candidate of color becomes the only option. No others are even worthy of consideration. And as the late Professor Derek Bell explained in his book, Confronting Authority, Reflections of an Ardent Professor, excuses like gettability get used to defer current candidates of color for the even more promising, though not yet identified or not yet in existence candidate in the future pipeline. But what enables excuses like gettability to be shifted in so many ways to exclude candidates of color? Well, applying shifting standards to candidates is simply another form of bias that creeps into the decision-making process. People shift standards to reinforce what they already believe. For example, studies show that evaluators shift their standards to fit their prior beliefs about who will do a better job in a particular area, such as when they overrate men's competence and underrate the abilities of women and minorities. For instance, in one study, participants were asked to determine whether the leader of a fictional organization was white or Black. The study found that participants attributed successful organizations to white leaders more than Black leaders. Additionally, white leaders received more favorable evaluations than Black leaders when success was perceived to be because of a leader's internal characteristics. The study's authors concluded that whiteness was a perceived characteristic of successful leadership. And faculty hiring, the same applies. If faculties are underrating candidates of color, they will shift standards to support the outcomes they desire. And consider yet another study which emphasized how race plays a role in how our brains might perceive candidates' abilities. The study measured whether knowing an employment manager's race would lead to predictions about the characteristics they were likely to have. In particular, it asked a group of evaluators, students in business school, to characterize the attributes of Black and white managers. The study found that evaluators were less likely to ascribe ambition and competence to Black managers than they were for white managers. White managers were also more likely, though, to be characterized as manipulative, while Black managers were more likely to be characterized as having better interpersonal skills. Whites were also considered more polished than Blacks in managerial positions. And what the study authors ultimately concluded was that the content of the race-based stereotype, rather than its negative or positive characteristic, was what actually explained the gap between Blacks and whites in managerial roles. Here too, we see an explanation for how a positive stereotype, like the superstar candidate of color with too many offers and schools bidding over them and fighting over them, can work to a candidate of color's disadvantage. It doesn't matter if the stereotype is positive. Instead, what matters is the content, and the content of being so overqualified that one is going to be fending off offers gives the faculty a way to rationalize a decision to exclude, and to rationalize it in a way that does not make them appear to be racially exclusive or discriminatory. These rationalizations are one of the reasons why it is so critical for faculty appointments committees to discuss and define what they are looking for in a candidate, to write down those criteria in a rubric in the order of importance before they even begin a search. Because another type of shifting of standards that occurs in faculty searches is the backtracking from established and agreed upon criteria right in the middle of a search. And when those criteria have been agreed upon after lengthy discussions, and most importantly, are in writing and put in writing after those discussions before the search, one then has ammunition to stop one form of shifting criteria in the middle of a search, at least stopping it in a more explicit manner, right? Otherwise, another tool, as I point out, hinted at, that is employed in literally shifting is the literal shifting of agreed upon standards to fit the desires to hire the majority candidate in many instances, as opposed to the candidate of color. After all, what studies have shown us is that when a particular job is gendered or raced in the mind of some evaluators, whether people perceive what a professor looks like as being gendered or raced, whether consciously or not consciously, the attributes that make the job gendered or raced in their minds will come to look as if they are necessary for the job, even when they are not relevant. We also see shifting standards in other ways. One of the most common tools of shifting standards when it comes to diversifying faculties, racially diversifying faculties, is literally the shifting of the meaning or the focus of diversity. Often when the importance of racial diversity on faculties is brought up or discussed, a common retort for standard shifters is, what about intellectual or ideological diversity? Or in other words, increasing the number of politically conservative faculty. And frequently, these things don't have to be in competition. One can both try to add to the racial diversity and intellectual diversity of the faculty, and yet it gets presented as a zero-sum game. At the same time, try presenting a conservative faculty, a member of color as a candidate, and watch the standard shift again. Despite the candidate's actual politics, the candidate of color may not be viewed as a real conservative precisely because of their race. And as I pointed out earlier, others' prior beliefs about what a conservative looks like, right? Prior beliefs, again, come into play. The final shift is a shift in flexibility of usually what people view as must standards when it comes to people of color. For example, and these are great things, and we wish more faculty would consider these things. First generation college or non-elite pedigree may become the driving plus for a majority candidate, even as most of the candidates of color in the pool may be first generation college or have quote unquote non-elite pedigrees. And yet committees will often remain silent about these and highlight them as strengths of other candidates. Preventative measures such as creating rubrics are the most effective way to avoid these shifting standards, but they alone cannot eliminate the rationalizations that the brain seeks to confirm its biases. Highlighting, naming, exposing, and honestly speaking about such shiftings, particularly if there are any in the in-group who are courageous enough to use their privilege to bring them to the fore and to challenge those who share their identities, which is not always an option, are the most effective ways to grapple with shifting standards. But for now, we must shift to dual career status and relationship discrimination.
So in this section of the talk, I'm going to focus on dual careers and relationship status discrimination. But first, I want to thank Tristin Green, Michelle Travis, and Maria Ontiveros for organizing these yearly events, and for Kenji Quijano for coordinating them, and to Dean Frywall for bringing us together today. So in this section of the talk, I'm going to focus on the obstacles that people of color and women face with respect to their marital or relationship status. These are biases that are related to relationship status that make women and people of color in general seem less than ideal candidates, presumably because of the choices that they've made or are expected to make with respect to professional and domestic work-life balance. So there's this narrative that focuses on the choices of women and people of color that ignores the structural obstacles to hiring, in this case of academics and relationships. This relationship status discrimination, as we're calling it, has been documented in studies, and it can appear at several stages of the hiring process, including at the interview stage, during the decision-making process, and in recruitment. A complicating factor in relationship status discrimination is the treatment of interracial couples. And Angela Onwuachi-Willig has examined this form of intersectional discrimination in previous articles and books, and I will try to summarize it here, and its presence in hiring decision-making process, which creates strong barriers to the advancement of candidates, even superstar candidates. So first, some background. Over 1/3 of American faculty is comprised of dual career couples. Academic couple hiring has increased from about 3% in the 1970s to 13% in 2000, and even greater today, although there's not good statistics. One study from the early 2000s found that nearly 1/3 of underrepresented minority faculty are partnered with another faculty member. Women have academic partners at higher rates than men, and rates of dual career hiring are higher among women than men. In addition, dual career hiring tends to be important for gender equity in certain fields, like in natural sciences, where 83% of women and 54% of men in academic couples are partnered with another scientist, and in law, where 79% of women in academic couples are partnered with another lawyer or law professor. So in part because women are more likely than men to be in academic couples, any disparities negatively affecting academic couples serve to structurally disadvantage women in academia and perpetuate broader inequities. But that's just part of the story, and I'll get to that in a few minutes. So what are some of the reasons that faculty resist academic couple hiring? 3 in general are departmental autonomy, concerns about equity, and concerns about quality of an accompanying spouse or partner. So there's this belief that partner hiring is an accommodation that puts universities in a hostage situation, as one study respondent stated. And this is a belief that hiring a spouse as an accommodation is in itself a structural barrier to developing policies. Structural changes to policies that don't threaten departmental autonomy have been created, and they are successful. There's concerns about equity, and these, as well as concerns about quality of accompanying spouses or partners, seem to be reactions to situations in which hiring policies are not transparent or don't exist in some written, clear form. So there's concerns about nepotism or favoritism or even a conflict of interest. And then there's also concerns about quality of a potential hire. So this narrative is created around these concerns is first, the structure of the market is what creates the problem. That is, the market's a limited one. It's difficult to get one job in academia, let alone 2. That hiring is done on a yearly basis, once a year, and it's done in a competitive atmosphere for both schools and candidates. So schools have to make decisions under time pressures because they're competing for the best candidates with other schools. Second, the personal choice about romance and career exacerbate the problem. So here we get a narrative about choice of the individual rather than a problem with the institution. On top of that, a parenthood penalty is added to the calculus for women. So in many institutions, but especially in those where dual hiring policies have not been accepted university-wide, we see relationship status discrimination occurring at several points in the hiring process. Sociologists have identified 4 potential areas where relationship discrimination occurs in the hiring process. Before the interview stage, the assumptions going into the search is that the ideal worker is one who's fully devoted to work. So how does that lead to women as less than ideal candidates? It's an assumption that runs against women in relationships because employers or hiring committees might view the presence of a partner as a greater threat to productivity. The stereotype is that women tend to split their time between professional work and domestic work much more than men do. These cultural stereotypes then depict women as more relationship oriented than men, so women are more likely to make career considerations than men. At the interview stage, the reticence that some faculty might feel about couple hiring manifests itself in the types of questions that might be asked during interviews. Studies show that women get asked about so-called trailing spouses more than men do. The assumption that women are not movable means that women are excluded as viable candidates at the interview stage. Men with partners are moved forward because the assumption is that women will move for their male partners. At this stage, this is the stage at which you hear administrators and committee heads warn committee members not to ask about marital status or relationship status because it's illegal. Implicit bias hiring trainings make a big deal of warning faculty that questions about relationship, pregnancy, plans to have children are off limits. Despite these warnings, studies have shown that women are asked about status and men are not as much. During the decision-making process, this is the point where bias has real consequences. A recent study of faculty hiring committees in several departments of a university found that although faculty understood that they shouldn't ask about relationship status, faculty still thought they could use the information if it was discovered in some other way, or if the candidate brought it up themselves. Decision-making processes about viable candidates consistently brought up women's relationship to determine whether a candidate was, again, gettable. All of the committees observed in the study took as a given the assumption that women in relationships were less likely to accept an offer unless their partners could also get desirable employment, and therefore they were not gettable. The same study found that perceptions of desirable employment were commonly derived through committee member stereotypes of occupations and acceptable jobs rather than information articulated by the applicants. These perceptions turned out to be deeply gendered. For academic couples, committees viewed lower status, lower security jobs suitable for women, but not for men. And this may be, by the way, why women in dual career hires are more likely than men to be offered non-tenure track jobs. And then finally, in the recruitment process, there's differential treatment of men and women. When relationship status was discussed for men, it was treated as a recruitment issue. And committees saw men in dual career relationships as gettable, and that the problem was going to be how to recruit them. On the other hand, two bodies were seen as an organizational problem and as a legitimate basis for rejecting female candidates and for not making them offers. So I'm going to pivot a little here to focus on interracial relationship status discrimination. As I said, Angela Onwuachi-Willig has written a lot about this, and she's written eloquently about the issues at the intersection of gender, class, race, and relationship status discrimination. At this intersection, we see how stereotypes about who marries whom can combine with the biases that I've just talked about in hiring processes to produce a form of discrimination that Title VII just can't capture. In her book, According to Our Hearts, Dean Onwuachi-Willig describes how job descriptions and duties reflect an assumption that candidates are coupled as monoracial and as heterosexual. While Title VII has been found to apply to harassment because of interracial relationships, what's more difficult to capture is the type of bias that prevents employers from hiring candidates because of their interracial relationships, or because of uncertainty about how that kind of relationship will strike other members of the public, especially if the spouse is expected to play a role in publicly supporting the employee in work duties. So one case in particular captures this type of discrimination. In Holcomb versus Iona College, a white college coach was hired when he was single. He married a Black woman a few years after he was hired. Part of the job was to attend college events and socialize with alumni, other administrators, and current and potential donors. He was expected to appear with his wife at these functions. And at some point, Iona made cost-cutting measures and terminated Holcomb and a fellow coach who also was Black. He continued claiming discrimination. He sued claiming discrimination based on his interracial relationship. The trial court granted summary judgment, but the Second Circuit reversed the summary judgment, ruling that racial discrimination may not focus solely on the individual and his race, but rather the individual as part of a collective or race mixing. So assumptions about Holcomb's duties could be found to be discriminatory if they turned out to create expectations that he was married to a woman of the same race. Even this case, however, fails to capture what Dean Onwuachi-Willig terms prejudice against interracial couples, where unwritten job requirements go beyond the official job description. So this is in part because the unwritten job requirements are assumed, they're unspoken, and they're uncompensated. Yet they form part of unconscious impressions that then show up in things like student evaluations, merit and promotion decisions, teaching, and service assignments. So the problem with Title VII is that it doesn't cover interracial relationships in the statute or this uncompensated support role of spouses. And as we've seen, Title VII interpretations have only reached as far as prohibiting this association discrimination. The intersectional discrimination involved in interracial relationships requires a better understanding of both this unwritten job requirement that some academic positions hold, as well as the bias built into expectations about who should marry whom in our society and how that plays out in the hiring process. So, given the types of discrimination that we still see in hiring processes that involve relationship discrimination, we suggest some prescriptions that might come out of litigating these kinds of cases. First, ensure formal dual career policies. These are agreed upon written protocols or guidelines for dual career hiring that should be able to flow efficiently through an institution. Universities should also develop agreed upon and written policies or guidelines for vetting requests for partner hiring and seeing that process through the university. The ultimate goal is to improve the process by which the partner hiring decisions get made. Also, dual career hiring policies require buy-in from all departments. So some form of incentive for future faculty lines might be an example, or incentives that counter the notion that hiring is a zero-sum game and that ensures departments don't lose the line if they make an offer and it's not accepted. Second, educate hiring committees that use of relationship status information in making decisions is discriminatory. It's not just don't ask that leads to discriminatory decisions. Third, make sure that the committees are aware of how gender and race stereotypes arise when committees test candidates for commitments to the university or to geographic location. These biases can be ameliorated in part by set and specific clear objective criteria and processes like standardized questions, criteria and scoring systems for one-on-one interviews, which is where questions about a candidate's interest in a position or locale take place. And as studies show, these are questions that get asked mostly of women and not so much of men. And then finally, prohibit outside searching that tests information provided by candidates through things like social media searches or off-reference calls or other forms of investigation. This type of search happens in a way that assumes the behavior of women especially, and allows committees to subconsciously make calculations on behalf of female candidates. As the study points out, the committees become gatekeepers that make decisions on behalf of workers in a way that encourages conformity with traditional gendered expectations. So rules for hiring should diminish this unconscious bias as much as possible. So in conclusion, the narrative of choice is alive and well in academic hiring, and it plays itself out in the ways that committees think about why candidates choose not to come to a school after a process has occurred. Rather than focusing on the structural aspects of the hiring process, committees tend to focus on the choices that candidates make about family, about geographic location, and about domestic and professional work balance. The choice defense has been around for quite a long time, and it plays itself out in many of the same ways that we saw it played out against women seeking managerial positions in EEOC versus Sears Roebuck in the 1980s, for example. Choice plays a role in explaining the differential standards and the shifting standards applied to women and people of color that Dean Onwuachi-Willig spoke about. So this part of the presentation hopes to reveal some of the ways that choice is actually made for some candidates, especially when committees are allowed to consider relationship status in their calculus about whether a candidate is gettable. We argue that this is a type of discrimination that should be recognized and litigated under Title VII because it operates to make women and minorities less than ideal candidates, even when they are excellent. So I'm going to stop for now. I think, is it Professor Ontiveros is going to take the cue for questions, for a question and answer session.
Great. Okay. Well, thank you too. That is so fascinating and relatable. And we really appreciate you bringing that research and those thoughts to us today. Yeah, so if people have questions, they can either type them in chat, or you could just put in chat, hey, I've got a question and I can call on you. I've got a couple of here already. So the first one is, if well, actually, let's start with the broader question that some people have. You presented an interesting case about professors, and maybe some of us think in particular about law professors. Does these same arguments and ideas that you've had apply more broadly to other types of segments, other industries, other employers?
Yeah, I mean, absolutely. I mean, I think they apply in any context in which you, well, you know, I mean, so for example, all the biases apply in any context in which you might have the same things operating, right? So any context in which people might have prior beliefs about who should be or what people look like in a particular position, or what are the qualities that fit best with a particular position, and those qualities are, you know, masculinized or raced or gendered in any particular way, absolutely, it's going to apply in the same way. Anytime you've got gender and dual career status and mobility, right, operating, those same questions are going to apply, right? I mean, so I think these can be applied more broadly. I mean, I think we're speaking to our people, right? Because these are things that we've seen over and over play out in our own communities, and so we were targeting a particular audience.
And in part, we're also bringing in what many people already know about Title VII and the rest of the world to academia, right? Academia feels to me like the last black box or something, right? And we don't know very much about what happens in hiring committees and what happens at the hiring process, unless we have these studies that are increasingly coming out about how decisions get made in academia. So you see very few cases, right? Very few hiring cases in academia, very few tenure denial cases, because it's really hard for attorneys, for lawyers to get their hands around what's actually happening in these hiring committees. So part of what we're saying is, we know all of this already exists in the world, right? How does it apply to what we're doing in academia? And what is it that we as academics can do to bring in the types of prescriptions that have worked outside of academia into academia? And that's why we say specific, objective criteria written down that doesn't allow you to shift. All of that deals with the types of subjective criteria that lead to discriminatory hiring decisions that we've already seen played out in litigation outside of academia.
Okay. So there's a couple of questions, and I think I'm going to paraphrase them this way, based on what you just said, Professor Saucedo. Maybe it's a way of saying, is gettability ever appropriate as a stated criteria? So for instance, someone said, if you only have authority to have one person, isn't it rational for a faculty to consider gettability, especially if they can't make more than one offer and might lose good candidates waiting for the non-gettable candidate to respond? And there's, sort of a couple of other ideas about this idea of it being rational to consider gettability. And from what I took from what Professor, from what Dean Onwuachi-Willig said, you don't want an institution to shift from stated goals at the beginning to, well, now we have to consider gettability, so we can't think about that candidate. Is it okay to think about gettability as a rational criteria from the get-go?
I mean, I think absolutely. I think absolute gettability can be one of the things that you focus on. But I think the question is, are faculties using gettability in different ways for different candidates, right? That's one of the questions, right?
Mhm.
So and one of the things that you see is you see faculties really employing gettability quite differently for candidates of color than they are applying them for white candidates, right? The other thing is and then for candidates of color, gettability is not only is it getting applied differently, but it's getting applied both to exclude in all ways. It's not only getting applied to exclude the person altogether from consideration, which could be completely rational, right? If they're limited time, limited resources, all those things. But then there also the fact that some places decide that's the only person that we want, right? Even though that they can somehow make distinctions among white candidates, that's the only person that they want. That then becomes a reason not to consider any other people of color, right? And so it's the particular way that it operates because people are not being reflective about their own particular biases, and it's operating in a very distinct way for candidates of color.
And there's also the way that gettability is used, right? So you might decide that you're going to use it at one stage of the process, and then you use it across the board at one stage of the process, right? But what we're seeing, that what the studies are saying with respect to relationship status discrimination, for example, is that gettability keeps women and people of color out of the pool before the interview stage, at the interview stage, and during decision making. And gettability doesn't come up for men until the recruitment part, right? So it doesn't become an institutional problem for men, it becomes an issue of recruit. Well, we're just gonna have to work that much harder to get this person here. The other thing is the assumption of the question, I think, is really important, right? If we only have one candidate, what are we going to do? So that's that's a structural institutional problem that institutions have to deal with, right? And so some institutions have said, have basically put out to their faculty, we want you to think in terms of 5 and 10-year plans, right? So that maybe you don't hire somebody, right, this time, but you'll get 2 people next year, or that sort of thing, right? So that you're thinking not in terms of what can I get right now, but in a much more open way about who you can recruit, right? And studies have shown that when you do these sort of open searches, you're gonna get more people of color and more women into the pools.
Okay. And it's I think more of a comment than a question, or perhaps an affirmation of that. Someone said, if gettability, you don't know if someone's gettable until you talk to them. And that's, it can often be a proxy for stereotypes about, who you're going to be able to get.
And the issue then is and that's why part of what we are suggesting is that we don't even think about gettability, right? You cannot assume what that person is going to do. You cannot assume what that person's home life is. You cannot assume that a couple will decide to live on 2 coasts, right? None of those assumptions can be made on behalf of someone. And that kind of response to gettability, I think, would shut off the discussion of gettability for as a as a criteria, as a specific criteria when you are looking for a candidate. And that's why Dean Onwuachi-Willig's suggestion that we think about what specific criteria we're looking for before we even see the first person that walks in the door. And usually if you do that, gettability doesn't end up on the specific criteria rubric.
Okay. Here's a question that shifts a little bit to the issues around relationship status discrimination. And you mentioned that people should not be searching around for relationship status to inform, whether or not they think someone is gettable or how presentable the other half might be. Do you think it's fine to do similar research to determine the race of candidates in an effort to try to broaden an applicant pool?
Well, I'll let you start, Angela, and then
It's kind of a loaded question, but
You mean
Yeah.
like look up
you have the
someone on
brain power to
LinkedIn,
handle this. I am confident.
look at someone on LinkedIn to try to broaden their applicant pool or something like that? Or is that what the person's talking about?
Well, I think that it's, if you, as I take the question, if you have let's say you want a broad, diverse candidate pool, you have a variety of applications, and you're going to invite in, I don't know, 5 people, and you would like to bring in a diverse group of 5 people, but you don't necessarily know someone's sexual orientation or someone's race from the resume. Is it okay to go out and do research to determine those sorts of things?
Well, I mean, look, it's not illegal to do that. I guess I would say that it's not illegal to do that. It's funny because somebody was just doing an article, a journalist was just doing an article about it, but talking about how a number of companies do it, but how it actually backfires, right? In a number of ways, for a number of reasons, right? It actually doesn't actually end up diversifying the workplace. But here's what I would say too, right? And maybe it's unfair to say it. I think one of the reasons too is faculties or employers have to have a discussion about why is it important to have a racially diverse workplace, or why are all different kinds of diversity? Why is it important to have a workplace that is inclusive in terms of sexuality and gender identity and race, all why is that critical? And I imagine some of the things that'll come is it'll be about the perspective that somebody brings. It'll be about diversity within groups. I mean, the kinds of things that we saw in Grutter. And I guess my view is that if and it could be complicated. I mean, particularly around sexuality and gender identity, there may be many reasons why that would not be visible in anyone's application. But if in a faculty member's application, there's nothing that suggests that they are, in my view, that they want to discuss those issues, I don't think that it's the faculty's business to go out and look for it and then force them to be, to bring that into the criteria, right? Maybe that person doesn't really care about mentoring students. Maybe that person, I mean, you just don't know what it is. Is it cosmetic, or is it? I mean, maybe this is all unfair to say, is what I'm saying, right? It might be unfair to say, but it's hard for me to. I think there are lots of things that read on someone's description, or if you're faculty, if you want to get at those things, then don't have that. I think you don't go search for it. Ask every single. This is even a better answer. It's a better answer. Thank you. It's a better answer. The best thing to do is to have everybody do a diversity statement.
Yeah.
That's the best thing to do. Is to have everybody do a diversity statement. Why is that at best? You get to hear about how everyone is going to contribute to a culture of inclusiveness and equity at the institution, assuming those are values of the institution. But more importantly, you're going to communicate to everybody who walks in that door, regardless of whether they are, what their racial background is, regardless of what their sexuality is, gender identity, any of those things, that it is everybody's work to be engaged in doing diversity, equity, inclusion, and belonging work at the institution. And I think that's the best thing. The UC system does that. I think it's a great practice. It's a great requirement. Right? Doesn't the UC do that? Yeah. I think it's a great practice. We have, as part of our process, we look at record of inclusion, what somebody's record of inclusion. We also look at contributions to curricular diversity. And for us, we get that information. It might not be identity, but we get a sense of what they're going to bring in terms of the values and the reasons why we think diversity is important to our institution, and by looking at those criteria. That's what I would say.
So what Dean Onwuachi-Willig just went through, right? Getting through the answer is what we are suggesting that committees do. And what you end up with a set of criteria that is very specific of, if you have it, let's say you want a diverse, right? You want a diverse pool, or right, or you want diversity in your hires, then there's a whole discussion about what that means. And how this is the discussion that we're all having in the UC system now, right? Diversity statements are required, but nobody's telling committees how to use those diversity statements. So there has to be a discussion about what kind of information we're finding in these diversity statements and how you get it across the board from all of the diversity statements, right? When you do that, then you've identified, the committee itself has identified what is the value of diversity here. And then it makes sense to say, don't go out and look for any more information about these people, unless you're going to do it all the way across the board. And it just makes much more sense to ask yourself as a committee, why do we want this information? Why do we need this information? And what does it have to do with the teaching, service, and scholarship of the person that we're trying to hire?
Okay, so, and someone has asked, to what extent can or should the particular circumstances of a given candidate be considered vis-a-vis diversity and inclusiveness? But what I hear you saying, perhaps Professor Saucedo, is it's going to depend, and that the committees need to have that discussion up front and figure out what it is that their institution should be doing in that regard, or wants to do in that regard.
Their institution or their department, or their, right, what is the makeup of the department now, and what might be missing from the department that can be filled in with this particular position, right?
Okay, well, I'm mindful of time, and there's a few other questions in here, but I really think that we should probably be wrapping up. And so I don't know, Professor Saucedo or Dean Onwuachi-Willig, if you have any last comments you want to make before we turn this back over to Professor Travis to talk about some of the fantastic things our current students are doing.
Yeah, just thank you for the opportunity to work with Angela Onwuachi-Willig.
Right, it's been awesome to work with Professor Saucedo. Learned an incredible amount. It's been fun. It's been really fun.
Yes. Okay, great. So Professor Travis, if you want to turn on your video, that will bring you back into our conversation, and I will take myself out of it. Although I may leave myself here, depending upon what you say.
Thank you so much. Thank you, Professor Saucedo. Thank you, Dean Onwuachi-Willig, for your important work and for coming here today to share it with us. It's such a privilege and honor to have you as part of our community today. Thank you. So actually, I would love to invite folks now to feel free to turn on your video so we can see everyone at this point. This is the point at which I have the privilege of honoring and celebrating our program highlights from our Work Law and Justice program for the year, and announcing some awards. And so it would be fantastic to see people's faces as I share the good news, and we can applaud for each other's accomplishments. So let me give you a second. I'd love to see those of you who are able to join us back with the video. It's so great to see everyone. Well, as people are reappearing, I want to start by first again thanking our LELSA leaders and members. Again, LELSA is our Labor and Employment Law Students Association. This is the heart and this is the core of our program. We've had a number of really great panels that LELSA has organized this year, including a panel on California's AB5. We had a fantastic career panel just last week. And none of this would have happened without our amazing students. I want to in particular thank our LELSA co-presidents for this year, Mel Haddad and Amara Blades. Thank you so much for your hard work, your commitment. We appreciate all that you have done. I also want to do a quick shout out to the other members of the LELSA leadership team, which include Abby Mullet, Bianca Velez, Clara Murphy, Jordan Hameen, Renato Flores, Sol Nunez, Kaylee Smiley, Alexis Ballinger, Carlo Bustillos, Isaac Ariola, Natalie Del Cid, Rianne Briones, and James Rainwright. Thank you so much. And for those of you who are not graduating, we're excited to be working with you again for the next few years. Appreciate you so much. Next, I want to do a huge shout out to Megan O'Day, who put in an enormous amount of energy and tenacity to organize this year's USF Law Review Symposium. The symposium was titled Exploitation to Empowerment, Leveraging the Law for Survivors of Human Trafficking. It was an incredibly important event and topic. We had over 250 people register for this event. It was phenomenal. I learned so much. So thank you, Megan O'Day. It would not have happened without you. And next, I want to congratulate a couple of our moot court competition teams who have done so much to make us proud this year. First, I want to congratulate our Wagner moot court competition team. For those of you who don't know, the Wagner competition team is the premier national moot court competition team focused solely on labor and employment law. This year, the problem dealt with COVID-related safety in the workplace, so it's an incredibly important and timely topic. Our team members this year included Chad Washington, Mackenzie Sewell, and Nia Gamble. Thank you so much. You made us very proud. The coaches this year included Gabby Trapani and Jordan Hameen, and special shout out to our alumni volunteer coach, Megan Killian. And second, I want to thank the members of our Tulane NFL salary negotiation competition team. This particular moot court competition is basically a simulated negotiation, a contract negotiation based on actual upcoming NFL free agents. So really great intersection between our labor and employment law and sports law. This year, our team members included Eric Davis, Emilio Rojo, and Carlo Bustillos. And our coach was Spencer Ladd, who was a member of the team last year. So congratulations to all of you and thank you for your really hard work and for, of course, making us look really good. Next, I wanted to share our just incredible pride of about two of our rising 3Ls who are recipients of the very prestigious Peggy Browning Fellowship. For those of you who don't know what the Peggy Browning Fellowship is, this was established in honor of Peggy Browning, who's a very dedicated union side attorney, a member of the NLRA. And this fellowship program is really the national training ground for our future leaders in public interest labor law. And we have two recipients of Peggy Browning Fellowships this year. We're so proud of both of them. One is Renato Flores. He will be using his fellowship to work with Legal Aid at Work this summer. Congratulations, Renato. We're so proud of you. And our second recipient is Clara Murphy. Clara will be working with the union side labor firm Nyhard Anderson. Congratulations. This is such a huge accomplishment, and we're so excited to see where this is going to launch you and take you into your important work. So congrats. Next, I want to acknowledge 6 of our graduating students who have earned the Labor and Employment Law certificate this year. And this is a very huge accomplishment. Getting this certificate requires extensive coursework in labor and employment law. It requires the student to do experiential work in the field, and it requires the student to finish a very substantial writing project, a paper in a labor and employment law topic. And we have 6 graduating students who are getting the certificate this year. These certificate recipients will be highlighted in the graduation program that is coming soon. And we will also be sending all of these certificate recipients honorary sashes. I don't know if we have those to show or not. I don't remember if we have those, but they're sashes that we're going to send you with your graduation regalia, and you can wear them to honor your certificate for our graduation celebration. So those will be coming to you in the mail very shortly. So our 6 certificate recipients are, we're so proud of all of you. First, Barbara Carrasco. Congratulations, Barbara. See you there. Second, Spencer Ladd. Congratulations, Spencer. Third, we have Saskia Ledesma. Congratulations, Saskia. It's so great to see you. Next, we have Sol Nunez. Congratulations, Sol. So proud of you. Next, we have Patty Pengelinen. Congratulations, Patty. Just saw you. And last, we have Alexander Repaja. We're just so proud of all of you and excited to watch your careers as they take off. So thank you for your hard work, your dedication, your commitment. All right, and last but not least, my favorite part of the night, I get to add a new honor to our list of highlights. Each year, we have the privilege of selecting our most outstanding graduating students in our labor and employment law program, now our work law and justice program. These students will receive the USF Pemberton Award for Achievement in Labor and Employment Law. This award was previously known as the ABA Bloomberg B&A Award for the alums that are present today that were former recipients of it, now known as the USF Pemberton Award for Achievement in Labor and Employment Law. We've selected this year 3 graduating students who are receiving this award this year because of their academic performance in labor and employment law and because of their deep commitment to the labor and employment law field. Our award winners throughout the years have gone on to do just incredibly impactful work in all areas of labor and employment law. So these 3 graduating students, you are going to be joining an incredibly impressive group of alums who have come before you. So it is my pleasure to announce our first recipient. Our first recipient of the Achievement Award for Labor and Employment Law is someone who has actually already somehow amassed a wealth of practice experience in the labor and employment law field. She has worked at the EEOC. She has represented employees at Shake Law. She's represented unions at Weinberg, Roger, and Rosenfield. She has fought for workers' rights at California Nurses Association. This is someone who's been a previous member of our Wagner McCourt competition team. As a 2L, she was selected for the Vincentino Employment Law Scholarship from Jackson Lewis. And she's been active in LALSA since her first year. And probably what makes me the most proud of this individual is the way in which our first years and our second years talk about her as a mentor and a supporter and a friend, which makes me most proud of all. So our first recipient, if you haven't figured out from that description, is Amara Blades. Congratulations, Amara. And I think we have enough time. If you're welcome to just jump in if you want to say a couple words. We'll give you each the floor because we're so proud of you.
Oh, thank you.
I didn't
know if I should just jump in
yet, so no one has warning. So yeah, just put you on the spot.
Yeah, I just wanted to thank everyone so much, and especially our professors who have been so incredibly helpful to our club throughout this year. I know I've enjoyed my time at USF a lot, and I've been able to amass a lot of experiences in labor law and employment law. So I'm just really grateful and thankful that I was chosen for this. And, I'm just ready to go fight for working people and basically put to use what USF taught me, and just thank you so much. I really appreciate it.
Thank you. We cannot wait to follow what we know is going to be an incredibly impactful career. Thank you for all that you've done. Our second award recipient this year is someone who's also been a LELSA leader, a mentor, a supporter to our rising 1Ls and 2Ls. This person has been a standout in all of our labor and employment law classes throughout the curriculum. He is currently working at the employment law firm, the DeVito Law Group, previously interned for the Department of Labor, and has also been a supporter of inmate rights at Prison Legal Services. I am so excited to announce that our second award recipient is Mel Haddad. Congratulations, Mel.
Unexpected. Thank you so much. First of all, thank you to everybody who attended today. This was an awesome event, but I really wanted to send a thank you to the professors and advisors for LELSA. You three have been some of the best mentors I've had here. You've always offered words of encouragement, and you know, I've always felt a sense of belonging here. You know, and so thank you so much. I appreciate it.
It's our pleasure. Thank you so much. We're so proud of all you've done. Looking forward to watching what's next. And our third and final recipient of the USF Pemberton Award for Achievement in Labor and Employment Law is someone who has been a top performer in our labor and employment law curriculum. This person has earned 2 Cali Awards along the way in our courses, has been both a participant and a coach in the Tulane NFL salary negotiation competition team. He has worked at the EEOC. He served as a research assistant doing employment and labor research, currently writing a paper on employer COVID vaccine mandates. And somehow this person has managed to make time currently to be a law clerk in the Labor and Employment Law Department at Jackson Lewis. Our final award recipient is Spencer Ladd. Congratulations, Spencer.
Thank you, Professor Travis, and I promise I'll get that draft to you soon.
Good job.
No, but just really want to echo what Amara and Mel said, who, you know, congratulations to you two as well. You know, I love having class with both of you. We just have such a great set of professors at USF, and I just cannot express how much I've enjoyed my time here. And I just really like to see the strong program that you three have created, and just really hoping to continue the tradition. And thank you to our speakers tonight too. Really great stuff.
Thank you, Spencer. So Amara, Mel, and Spencer I will be sending you some formal certificates and a letter of congratulations, and you will all be receiving honorary cords that you can wear with your cap and gown. Those will be coming to you in the mail with your cap and gown packages soon. So your honorary cords are on the way, and you will also get a shout out in the graduation program as well. Now, normally, this is actually the time where I'd be like calling the 3 of you up to the front of the podium at the 9th Circuit, and I'd be giving you all a huge hug. And unfortunately, we can't do that today. But I'm hoping that maybe we can unmute ourselves and maybe actually give you an audible round of applause for what you've done in lieu of a hug. I'll owe you one, and just share our appreciation with your accomplishments. Thank you very much. Love it. And lastly, I wanted to just thanks again our keynote speakers, Professor Saucedo, Dean Onwuachi-Willig. Thank you so much for your important work, for taking time to be with us. We're just so proud and honored. And a final shout out to Kenji Kihano, without whom this never would have happened. Thank you, Kenji. Thanks to our students, our amazing alums who show up to this, what I view as like a mini reunion for us every year, our staff and our friends at the law school who joined us tonight. We look forward to seeing all of you in person at the beautiful 9th Circuit Courthouse next year for what will be our 17th annual Jack Pemberton Lecture on Workplace Justice. So thanks to all of you. It was wonderful to see you.
Thank you all for coming. Have a good night.
Thanks, everyone.
Thank you so much. Take care, everyone.